Good afternoon. I trust you are all well. Thank you for joining our live webinar on the general topic of family law. Generally, we deal with child custody, child maintenance, divorce, relocation, consent when it comes to passport applications, and so on. Today's topic, still dealing with a general theme. However, it deals with the question, do you have a legal strategy? That is a very important question I'll ask anyone that comes to my office for advice on how to be successful in his or her case. Legal strategy, obviously, you want to win your case, you want to be successful in your case. For example, if you are applying for child maintenance, what is your strategy? How are you going to go about in receiving the amount of maintenance you are seeking, you are requesting? And in order to do that, you have to have a strategy. And based on your strategy, you can determine, or it would be determined, whether or not you were successful and you got what you have expected. Therefore, if you are applying for child maintenance and the other party does not want to pay, he or she is not cooperative, what is your strategy in convincing the court that you are entitled to the sum requested, despite what the other party is saying? So we are dealing today with the issue concerning your strategy, your way forward. Is your strategy to apply for child maintenance in the maintenance court and hope on the sympathy of the court? Therefore, your strategy is sympathy. Or is your strategy, on the other hand, to present to the court a full outline of your income, your expenditure, that of the minor child's expenditure, and also what you presume the other party can pay, present to the court logically, trying to convince the court that you are entitled to this amount of money? Or is that your strategy? Or is your strategy to convince the court that the other party has no interest of paying child maintenance, and that's it, and therefore the court must give you what you want? Or is your strategy, the last one, that the court must give whatever you ask for, and that's your strategy? Regarding aspects regarding child custody, a child custody battle, for example, where the one parent does not want to allow you contact to the child, what is your strategy? Is your strategy to be sympathetic, for the court to be sympathetic, for the court to be emotional, and all that you'll be dealing with is basically bad mouthing the other side? So your strategy is, he had an affair, he would not involve himself with our family, he would always argue with me, 10 years ago he hit me, he assaulted me, he's a bad person, and based upon that, he is not allowed to have primary care or 50-50 contact and care, or he's not allowed at all to have any contact with a minor child. Is that your strategy? Or is your strategy to explain to the court that you would like to remain the primary caregiver of the minor child because you can look well after the minor child, you have always been doing so, and you're comparing it to the other party, how the other party circumstances are compared to yours? For example, the other party never ever cared for the minor child. The child is quite old, the child has a routine where you are concerned, and it would be in the minor child's best interest to remain in this routine. So that's your strategy, that's where you're going to. I welcome you. If you have any questions, pose your questions regarding child maintenance, child custody, and so on. I'll be happy to try my best to assist you and formulating a strategy, either by just listening to what I have to say, and we take it from there, or you're welcome to pose a question on our Facebook live page, the Advocate Muhammad Abduroaf Facebook page. As you can see on my right-hand side, there is a Facebook live screen. You can see me, a little small person on the bottom right-hand corner of that specific screen. I'll be looking at this specific screen for any questions that you may have. If you do not have any questions, wonderful, I'll continue speaking. However, if you have any questions, feel free to pose them and I will try my best to answer it. I am only looking at the Advocate Muhammad Abduroaf Facebook page. Please note, nobody can see you. If you pose a question, it's too blurry into small for anyone else to see. But feel free to pose it. I'll keep an eye on it. I will read it out. I shall read it out. And at the same time, we can engage and we can try to formulate a proper strategy for your specific case. Strategy is very important. If you do not have a legal strategy, or your attorney doesn't have a legal strategy, or your advocate does not have a legal strategy, or I do not have a legal strategy, how can I be of any benefit to you? Should I go through the motions, appear on your behalf, go to court, tell the court, my client would like to have contact, he is a father, that's it? Or should I push your case? Should I analyze the other party's case and find the weaknesses therein and determine how am I going to deal with your case? I'll focus on this, I'll focus on that. What is our ultimate goal? Our ultimate goal is obviously to get your contact, to have a regular contact for you. But how are we going to do it based upon the other party playing hardball, making your life miserable, making your life very hard? How are we going to do that? What is our strategy? We need to formulate one, a plan of action on how to be successful in your specific case. All cases are different. Every case under the sun is different. The age of the minor children are different. The parties' circumstances are different, the mother and the father. The mother lives in Cape Town, the father lives in Durban. The mother lives in this specific suburb, the father lives a half an hour drive away. Or the mother lives opposite the school and the father lives around the corner. Those are the circumstances. Each family is different and each case is different. Therefore, it's very important that you have a specific plan and a strategy in trying to obtain the best possible solution for your specific case. Some people's strategy are to delay matters. For example, a father wants to see the minor child. I'm using a stereotype example. It's easy for people to understand it. When I mention the mother wants to see the minor child, the question is, why does the father have contact? Those questions all get posed. I'm not dealing with that. So, the father wants to have contact with the minor child. They were separated. The parties divorced. Whatever the case may be, it all happened recently. Now the mother decides to refuse contact to the father. What does she do? She knows that she has a legal obligation to afford the father care and contact. She won't get far with that. She creates a scenario. I'm representing the father in this case. She creates a scenario. She tried to cause some type of conflict between the minor child and the father. There might be an argument. She says, no, Dad, you are now being abusive to the child. She approaches a domestic violence court. She obtains a protection order, interim protection order in favor of the minor child, stipulating that the father is a danger to the minor child. The father scolded the minor child out, and he might have given the child a knock on the bottoms, whatever the case may be. That is her strategy. She's bringing in domestic violence into the picture. What happens then? How do you deal with that? If a client with that specific scenario comes to my office, we have to figure out how can we cause him to again obtain regular contact with the minor children. How do we do that? We need to have a plan. We need to have a strategy. We cannot go into the domestic violence court with all guns blazing and saying, this is not true, this is a lie. It did not happen. Yes, that ultimately is what you want to prove to the court, that it is a lie, that the father has not assaulted the child, has not abused the child. Or maybe he did. The father agrees to that. But the problem is, he wants to have contact with this minor child. What is your strategy? Are we getting a social worker on board? Are we getting a psychologist on board? Are we defending the case and stipulating that it did not happen, if it did not happen, etc.? What is our plan of action? The mother has a strategy. Her strategy is to bring in domestic violence, to bring in a scenario to show that the father cannot behave himself when he's in the minor child's presence. The mother causes a problem. For example, she feeds the minor child with a lot of sugars, etc. And now the child will not behave, will misbehave. And she knows when the child misbehaves, the father gets angry. These are factors applicable. So you must have a strategy, and the person with the best strategy will obviously be successful. I do not agree with those type of strategies. My hypothetical scenario here where the mother plays these games, lies to the court, and approaches a domestic violence court with the ultimate purpose not to protect the child, but to limit the father's rights of contact to the minor child. I have a problem with that. And many magistrates see through that. It happens all the time. The magistrates look at the facts. The father, with his strategy and how he presents his case to the magistrate, she can see, or he can see, this mother is using the child as a pawn to what? The mother is trying to use the minor child as a pawn in order to punish her father for divorcing her, for breaking up with her, whatever the case may be. Therefore, it is extremely important that parties will have a strategy when dealing with legal matters. Now, moving forward, what do you do? How do you plot and plan? Let us first deal with the child maintenance scenario. To be successful in a child maintenance case, a child maintenance matter, you need to know maintenance cases are mathematics. That's full stop. It's about rands and cents, affordability, economy, etc. Question is, what does a minor child cost? First question, simple question. What does a minor child cost to live? Simple. Food, clothing, accommodation, education, etc. That's what does a minor child cost. We need to get a figure. It applies to both parties, the mother or the father, the claimant or the respondent, doesn't matter. We need to determine what does the child cost. If the child costs 10 Rand per month, I'm using silly figures, 10 Rand per month. That is the base. The second question is, what should either parent contribute towards that 10 Rand per month? Should the mother contribute something? Should the father contribute something? Is the mother employed? Is the father employed? How wealthy are the parties? What are the proportions of the income? All these factors comes in afterwards. Therefore, your strategy should be first to unpack the needs of the minor child. There are various aspects which you have to look at. For example, clothing, food, medical, etc. You need to deal with each one of them. You need to have a strategy for each one of them. Try to convince the court. Why does a minor child require a pony? Is it important? What is your strategy? What is your plan behind requesting that? How do you plan on justifying that specific expense? What is your plan? I justify because the parties used to, during the marriage, have a pony on the premises, on the plot, and the minor child is accustomed to having a pony. The parents themselves were brought up with ponies, and ponies are part of their lifestyle. That is a strategy, that is a plan, and you are going to present that specific case regarding that. I must not bring these difficult examples because it puts me on the spot. I put myself on the spot when I have to explain it. But nonetheless, that is your strategy. When it comes to extramural activities, you are requesting that the other party should contribute towards at least 50% of the minor child's extramural expenditure. Here you now come with a scenario where it comes to, for example, netball. Why? Netball is very expensive, maybe. The shoes, the clothing, etc. And now you'd like the court now to make an order that the other parent should contribute towards the minor child's expenditure when it comes to netball expenses. 1 second, excuse me for this. That's better. What is your plan? What is your strategy behind that? How are you going to convince the court that netball is an important aspect when it comes to child maintenance matters? That's very, very important. If you cannot do that, the court will obviously dismiss it because the other party is saying is not an important item, because the other party also has a strategy. What would be a bad strategy? A bad strategy would be to present on a piece of paper stipulating, I require so much money for maintenance because of X, Y, and Z. And I believe that is fair. Is that your strategy? Is that how you are going to present your case? Now the problem comes. You are stipulating that the minor child costs 10 Rand and your income is 9 Rand for the month. How does that make sense? If the child costs this amount of money and your expenditure and your income is much less than that, we did not even factor into the equation your personal expenditure. So the whole strategy, the whole scenario is incorrect. It happens often. We have a party which I not I represent, but which I see earns, for example, let us say 10,000 rand per month, but the household expenditure for the last year was 30,000 rand per month. We're going to fill in the form. Now, there's one of two ways I can unpack this. Either the mother had a very huge credit account whereby they allowed her for the last year 20,000 a month of credit. So it comes to 240,000 rand for the year, 20,000 times 12, and she owes 240,000 rand to the bank or to someone because the child does cost 20,000 rand more than what she earns. Okay, fine, good scenario. She can show that, and therefore the other party needs to provide her with assistance. There is some logic behind that equation. But if she claims that the minor child costs 20,000 rand per month for the last year, and she only earns 10,000 rand per month, and the 10,000 rand per month gets used for herself, whatever the case may be, and she has no serious debt. The debt she has is most probably some clothing accounts. What's the logic behind that? Obviously, red flags appears because she could not have in any way have spent that amount of money on the minor child because the mathematics don't make sense. She should have been in debt. If her argument is that her parents assisted her, then we want to see proof of that. You need to have proof to show that the minor child cost so much money and the parents assisted her in obtaining or assisting her in maintaining the minor child. I'm coming with a lot of hypothetical scenarios. That's what I'm doing here. The purpose behind that is to make you think. Do you have a strategy? Let us move back to the child custody scenario. And I see no question, which is great, which I love about that. What generally happens is people watch these videos later on. They're working now, they're at work, they're collecting the kids, they're taking the kids to school. Unfortunately, I cannot have these videos every day at the same time. You know, I ought to have commitments and work to do, of course, like everybody else. I do know that people they watch these videos later and they post questions thinking the video is live. It's not live. I try to sometimes look at those questions and respond or deal with it live again, but generally I do not. So therefore, if you are watching this video, please feel free to pose those questions. Other people might answer it, but I apologize if I cannot get to it. Let us now deal with the second scenario, strategy, when it comes to child maintenance matters. Child custody matters. We dealt with the scenario earlier, but let us deal with a different scenario. Mom and dad divorced. Nice. Contact and care agreement, parenting plan stipulates mother is the primary caregiver. They share school holidays 50-50. Wonderful. No problems there. Child's birthday, no problems there. Mother's Day, Father's Day, Christmas, etc. No problems. However, a year later, the father believes and he feels that he should have 50-50 care over the minor children. His reason for that could be that when he agreed upon this agreement, this arrangement of reasonable contact every second weekend, he was a bit naive, he wanted to finalize the matter, etc. And the minor children could have been a bit younger, but now they are older. Circumstances have changed. He lives now closer to the mother's home, and he cannot see why it will not be in the minor children's best interest for him to have 50-50 care and contact. Basically, on a Monday morning, the minor children will wake up in his home, and the following Monday morning, the minor children wake up in the mother's home. So that's 50-50 contact care arrangement. My motto and my policy always is, if the parties can come to an agreement and they are happy with that, I am happy for them. I believe if the mother and the father work something out and they come to an agreement and they stipulate that this contact and care arrangement, no matter what other people may think, no matter what the court may think, the social worker, the psychologist, no matter what they think, this is workable and applicable to them, then, of course, done, I'm happy with that because you know your circumstances, you know your situation. If the scenario and if the situation is that the father should see the minor child once a month for 1 hour, but that works for them and they are happy with that, then wonderful, I'm not here to frown upon that. I prefer to have a workable situation, a workable solution where contact is structured and regular, as opposed to have a situation that's difficult and complicated, and where the parties are embroiled in litigation, embroiled in issues all the time. That is what I want to avoid as much as possible. So going back to our scenario, the father believes that it will be in the minor children's best interest for him to have 50-50 care. The question is, what is his strategy? What are the problems first? He agreed to this a year ago. It's a year later. The minor children are stuck in a routine. They're used to this. They have a routine. And the routine, centers around schooling, homework, assignments, extramural, and their contact with the father. They sit in that way. Now the father wants to change that routine for the minor children now to live within 1 week and with the mother 1 week, whereby he will take all those responsibilities in his week, and the mother will now have to take more responsibilities than she used to, but for 1 week, as opposed to having the minor children with her not having the minor children with her on every second weekend because the father would have contact on his specific weekend. Does he have a strategy? What is his plan? What is his case? What will he try to present to the court, to show to the court? Under a scenario like that, I will first have to determine whether or not the minor children would want to have such a strategy or such a care and contact arrangement. It's very important. Is it workable? Is it not workable? You have to look at the facts objectively. If the minor children are okay with that, or they would be fine with that, and they are, amenable to such a situation, great. And how will I do that? I can also teach that, that's fine. But I would prefer to have a childcare expert first to look into this matter. So my strategy would be, firstly, speak to the mother. Say what you want. I'd like to have 50-50 care and contact to the minor children. See what the mother has to say. If she says yes, wonderful. If she says no, do not go to court immediately. Get a third party on board first. They can speak to the mother. They can speak to the father. Speak to the minor children and determine what are the factors applicable. Is the situation a workable situation? What does the minor children think about it? All those things. Sort that out. If the expert recommends that 50-50 can work, or they recommend that they should proceed because of the circumstances and the facts, and the mother still does not agree to it, then I will say the party should try mediation. This is part of your strategy. Mediation, of course, quickly. You do not leave these things for months and months and months. Let it carry on for months and months and months. You try the professional report, 2-3 weeks, wonderful. Mediation, 4 weeks, 5 weeks maximum. You try to come to an agreement. If the mediation works, and a mediation that works can be one of two things. It can either mean that the one party that wants to get 50-50 now says no, you know what, I think 50-50 is not a good idea because now we've discussed it and we mediated it. Or mediation could work where the other party says, you know what, 50-50 can work, let's do 50-50. If the mediation fails, then of course the only way to deal with this matter would be to go to court. But then you'd have to advise the court that it would be in the minor children's best interest for you to have 50-50 or joint care over the minor children, equal sharing of the minor children. Now you're saying you just apply your strategy differently. You need to now think or argue or develop a situation whereby the court will be convinced that this 50-50 situation is or are in the minor children's best interests. You can refer to the professional report, the person that done the investigation, wonderful. Mediation, of course, failed. You can stipulate that the minor children wants to do it based upon the report as well. And you can bring some logic in. Unpack it for the court. The age of the minor children, their needs, your location, your capabilities, the working. For example, does the mother work? Does the father work? How are you to care for the minor children when they're in your care? How does the mother care for the minor children when they are in her care? Are they in daycare all the time? Are they in aftercare all the time? So when does she work? Etc. You need to paint a picture that the minor children will benefit from being in your care for half the time. That is your strategy. And that is how your lawyer and your attorney will argue the matter and present the case to the court. You have a strategy. And if the court, after having looked at your case, and obviously you pursuing your strategy to show the court that under these circumstances, it will be best for the minor children to remain in your care for half the week, and you convince the court, you will get what you want because you were successful in your strategy and you presented a very good case. But if you're only going to present to the court, I want to have 50 contact to my minor children because I'm the father, you won't get very far regarding that. Ladies and gentlemen, thank you very much for joining me on this live webinar. It's a bit of a difficult topic to discuss, and I know many of you are at work and so on. Nonetheless, I hope you benefited a bit, and I wish you all the best in your legal strategy when it comes to your case. Thank you very much.